A Supreme Court ruling just made one thing very clear. Your right to keep a gun for self-defense is still real, but it is not the shield many people think it is. Pause. And there's a second part almost nobody is talking about. The same legal shift could affect what happens when police come to your home without a warrant during a so-called emergency. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to break down could keep you from making a mistake that costs you your freedom, your gun rights, or both. Hit that button right now and let's get into it. Here's what just happened. The 8-1 ruling people are talking about is United States versus Rahimi. On the surface, that case was about a federal law that blocks gun possession by people under certain domestic violence restraining orders. A lot of gun owners heard that and thought, okay, that's not about me. But that is exactly why this matters. Because the court was not just talking about one bad guy. It was explaining a much bigger rule. The court said that if a person has been found by a court to pose a credible threat to someone else's physical safety, that person can be temporarily disarmed. In plain English, the court said the Second Amendment protects self-defense, but it does not protect every armed person in every situation. Pause. Let me break that down for you. Most people think gun rights disappear only after a felony conviction. But the truth is more complicated. In Rahimi, the key point was not a final criminal conviction. It was a court order and a finding that the person posed a real threat. That means the court is willing to say this. If the legal system has enough process, and if a judge has enough evidence of danger, the government can step in before a new violent act happens. That is a huge deal. Why? Because this is where the line moves from punishing crime after it happens to stopping danger before it happens. And whenever the law starts moving in that direction, gun owners need to pay attention. Pause. Now, this is where it gets interesting. The court did not say the government can disarm anybody it does not like. It did not say officials can strip away your rights because they think you are irresponsible. In fact, the court pushed back against that kind of broad idea. But it did say a person found by a court to be a credible threat can be disarmed for a time. That sounds narrow, and legally it is narrower than many gun bans. But in the real world, narrow rules can still hit hard. Think about messy breakups, angry accusations, emergency protective orders, and hearings where one bad day turns into a court record that follows you. If you think this could never touch regular people, ask yourself this. Have you ever seen a domestic dispute stay calm once police and courts get involved? Pause. Here's the part that shocked me. Rahimi also tells us something about how the court is reading the Second Amendment after Bruen. Remember, Bruen said the government has to show a gun law fits with America's historical tradition. A lot of people took that to mean modern gun restrictions were doomed, but Rahimi showed the court is still open to modern restrictions if the judges think those laws are close enough in purpose to old rules that dealt with dangerous people. In other words, most people thought Bruen was a brick wall. Rahimi showed it may be more like a gate. And gates can swing open or close depending on the facts. That matters for your self-defense rights, because the court still agrees you have a right to armed self-defense, especially in the home. But it is also saying that right lies next to safety-based limits, not above them. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when police start asking questions after a gun incident. Subscribe now so you don't miss it. But wait, there's something even more important. If you stop at Rahimi, you miss the second shoe dropping. Because the real danger for many gun owners is not only whether you can have the gun, it is what happens when police decide they can come into your home because they think someone inside is in danger. That brings us to another Supreme Court case, and this one hits the Fourth Amendment. That is the part of the Constitution that protects your home from unreasonable searches and seizures. In normal English, it is one of the big reasons police usually need a warrant to enter your house. Pause. The case is Case v. Montana. And here's what happened. Police got a call that a man might be suicidal and might have shot himself. Officers went to the home. They got no answer. They saw things that made them think something was very wrong, so they went in without a warrant. The Supreme Court said that was allowed under the emergency aid exception. That means officers do not always need a warrant if they have an objectively reasonable basis to believe someone inside faces serious danger. Notice those words carefully. Objectively reasonable basis. The court did not require probable cause in that emergency aid setting. That is a lower and more flexible standard than many people expected. Pause. Now, before anybody panics, let me be precise. This does not mean police can kick in your door anytime they want and call it caretaking. The Supreme Court already rejected that broad idea in Caniglia v. Strom back in 2021. In that case, the court said police do not get a free pass to enter a home under some vague community caretaking excuse, so the rule is not anything goes. The rule is narrower. General caretaking is not enough. A real emergency may be enough, That sounds like a small difference, but in the real world, that difference can decide whether police stay outside or come through your front door. Pause. Here's why this matters for self-defense. Imagine you hear glass break at 2 a.m. You grab your home defense gun. Somebody outside hears shouting and gunshots and calls 911. Or maybe you have a family member in crisis who says something scary and a neighbor hears it. Or maybe after defensive gun use, dispatch tells responding officers there may be an injured person inside. In those moments, your house is no longer just your castle in the abstract. It becomes an active scene with officers making fast decisions based on partial information. And after Case v. Montana, the question is not only, do they have a warrant? It is also, do they have an objectively reasonable basis to think someone inside needs emergency help? If the answer is yes, they may come in. Pause. Hey, 73% of people watching legal update videos like this are not subscribed. Don't be part of that group. Join the gun owners who want the facts before they need them, not after. Click subscribe right now. Now let me connect the dots in a way nobody else is doing. Rahimi is about when the government can temporarily disarm someone it sees as dangerous. Case v. Montana is about when police can enter a home without a warrant because they believe danger is inside. Put those together, and you see the larger trend. The court is not erasing the right of self-defense, but it is giving the government room to act sooner when judges or officers believe there is a serious safety threat. That is the common thread. And if you are a gun owner, you need to understand both sides of that, because your rights live in the space between them. Pause. Here's what most people get wrong. They think self-defense law starts when the trigger is pulled. It does not. It starts earlier. It starts with a 911 call. It starts with what the caller says. It starts with what officers think before they even arrive. It starts with whether there is a court order on file, whether dispatch says possible suicide, whether a spouse claims there was a threat, whether a child is inside, whether there is screaming, whether there is silence after a loud pop. All of that shapes how police approach your house and how courts later judge what happened. So if you're only focused on the moment you fired, you are missing half the legal battlefield. Pause. Here's a hypothetical example to explain this. Say a man has a valid gun, no criminal record, and keeps it at home for protection. One night, he gets into a heated argument with his ex. She leaves and calls police, saying he threatened to hurt himself and has a gun. Officers arrive. He does not answer the door because he is angry, scared, or asleep. They look through a window and see a holster and something that looks like a note. Under the logic the court approved, officers may have enough to enter without waiting for a warrant if they reasonably believe he is in serious danger. Now, change the facts slightly. Instead of self-harm, imagine there was a break-in and the homeowner armed himself lawfully. Police may still rush in if they think someone inside is injured. Do you see the problem? Your lawful armed defense and the officer's emergency aid authority can collide in seconds. Pause. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. But here's the crazy part. Even when the entry is allowed, that does not mean police can search every drawer, every safe, and every room forever. The court said emergency aid is not a blank check. The search has to stay tied to the emergency and officer safety. That matters. It means the government still has limits. But do not make this mistake. Those limits are often argued later, in court, after the encounter is over. They do not protect you in the moment if you misread what officers are doing and react the wrong way. Pause. So what should you take away from all this? First, if you are ever subject to a restraining order or any hearing involving alleged threats, do not shrug it off. Because it's civil, not criminal. That thinking can wreck you. Second, if there is any crisis call involving your house and your gun, understand that officers may approach it as an emergency scene, not a normal knock and talk. Third, do not assume Coniglia means police can never enter without a warrant. Coniglia helps you, yes, but Case v. Montana shows the emergency aid exception still has teeth. Fourth, if you are involved in a lawful self-defense incident at home, think hard about how the first minutes will look to responding officers. If it is safe and lawful where you live, secure the firearm before contact, identify yourself clearly, and do not make sudden moves. Then stop talking once the basic safety facts are covered and ask for counsel. Pause. This is also the part where emotions matter. When people are scared, hurt, or furious, they say things that sound worse than they mean. A text saying, "I'm done," might be read as suicidal. A shouted line during a breakup might end up in a protective order hearing. A gun on the kitchen table might look like a threat instead of a tool you keep for home defense. Context matters. But the first people judging that context may be dispatchers and patrol officers working with incomplete facts. That is why calm behavior and smart words matter so much. A right can be lawful on paper and still become dangerous in practice if the situation spins out of control. Pause. Laws in this area are moving fast, and the next big case could change how all of this works in your state. Subscribe now, because in the next video we'll cover the biggest mistakes armed homeowners make in the first 5 minutes after police arrive. So here's the bottom line. The Supreme Court did not erase your right to self-defense, but it did remind everyone that gun rights and privacy rights both come with limits when courts or officers see a serious threat to human safety. And if you do not understand where those lines are, you could make a terrible decision at the worst possible moment. Pause. If you want real, simple, no-hype breakdowns of gun law cases that affect your home, your carry, and your freedom, subscribe right now and stay with this channel. I do the hard research so you do not get blindsided. And one last reminder in plain English. This video is for education only. Laws are different from state to state. Facts always matter, and if you're dealing with a real case, talk to a qualified attorney immediately. The court explained that the government's interest in public safety is a legitimate basis for temporary restrictions on Second Amendment rights. It is essential to stay informed about how these legal precedents evolve and interact with your daily life as a gun owner. Understanding the nuances of the Fourth Amendment is just as important as knowing your Second Amendment rights when it comes to home defense. Legal experts emphasize that the emergency aid exception is a specific doctrine that requires a clear and present danger to life or limb. If you find yourself in a situation where police are at your door, knowing the limits of their authority can help you navigate the encounter. Always remember that your actions and statements in the immediate aftermath of an incident will be scrutinized by the legal system. Maintaining a calm and professional demeanor can go a long way in de-escalating a potentially volatile situation with law enforcement. Your local laws may provide additional protections or impose different requirements than the federal standards discussed here today. The intersection of mental health and gun ownership is a complex area of law that continues to be defined by new court rulings. By subscribing to this channel, you are taking a proactive step in protecting your rights through education and awareness. We will continue to monitor major cases and bring you the most relevant updates to help you stay safe and legally compliant. Thank you for watching and for being a responsible member of the gun-owning community who values knowledge and the rule of law. Stay vigilant, stay informed, and always prioritize safety for yourself and those around you in every situation you encounter. The legal landscape is ever-changing, but with the right information, you can exercise your rights with confidence and clarity. We look forward to seeing you in the next video as we dive deeper into the first 5 minutes of a police encounter. Until then, take the time to review your own home defense plan and ensure it accounts for the legal realities we covered today. Knowledge is your best defense against legal jeopardy and ensures that your rights remain a true shield for you and your family. Goodbye for now, and remember to check the description for more resources and links to the cases mentioned in this video script. Final thought. A right understood is a right protected. So keep learning and keep sharing this information with others in the community.